Which one are we, what cause number?
Oh, just we're gonna go on 523,
Okay.
352, and 431
Okay.
with the dismissal of the remaining case.
Tell me which one we're dismissing. That'll be the easier one.
Okay, we're dismissing 353.
353. Got it. Thank you. Good morning, sir. Are you John Jones?
Yes, ma'am.
And Mr. Wilkerson, will your client waive the formal reading in each case of the indictment?
Yes, Your Honor.
Right away, you can feel the temperature in this courtroom change. The prosecution makes sure everyone knows the victim's family is present, and that matters. In plea deals like this, judges often weigh the family's wishes heavily before agreeing to sentencing terms. But notice the judge's tone here. She already sounds skeptical of this defendant before the plea is even finalized. That's never a good sign heading into sentencing.
And obviously, Mr. Coleman, you've taken everything into consideration with regard to the facts, the jail incidents, as well as the wishes of the family in making these offers.
That is correct, Judge. And just for the court's information, there is a member or members of the victim's family here in the present of the room today.
Okay.
And I've conferred with her about the case.
Okay. Mr. Jones, this is difficult for me because based on your behavior, honestly, I don't want to go along with anything. But it sounds like if Mr. Coleman has discussed this with everyone and understands the underlying facts of the offenses, what has been going on in a jail, I'm going to go along really only because I trust him to the extent that I do. Do you understand?
Yes, ma'am.
In cause number 25, DCCR 0523, you're charged with a first-degree felony offense of murder, and that's from April 28th of 2025. And how do you plead to that charge?
Wow. That is an unusually blunt statement from the bench. Judges normally stay measured and clinical, but here the judge is openly admitting she does not like what she's seen from this defendant. The only reason she's considering the agreement is because she trusts the prosecutor's judgment. That tells you the defendant's behavior outside the actual charges, especially inside the jail, has already damaged his credibility in a major
Are
way.
you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
And then in cause number 24, DCCR 2431, you're charged with, let's see, and are we going on just, what counts are we going on that one?
Which case?
That's the unauthorized use of a vehicle.
What is just the first paragraph?
First paragraph should be fine.
So the state jail.
Yes, ma'am. Well, I'm showing only one paragraph.
So it is that. Okay, gotcha. So you're charged in 24 DCCR 2431 with the state jail felony offense of unauthorized use of a vehicle. And that's from October 15th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with.
And this is the massive legal detail that changes everything: concurrent sentencing. Even though he received multiple serious sentences, including 2 separate 35-year terms, they'll all be served at the same time instead of back-to-back. If these sentences were consecutive, this could have effectively become a life sentence. Do you think this plea deal was fair considering the charges involved? Let me know in the comments.
And then finally, in cause number 25 DCCR 1352, you're charged with the first-degree felony offense of aggravated robbery from September 18th of 2024. And how do you plead to that charge?
Yes.
Again, are you pleading guilty freely and voluntarily?
Yes.
And because you did what they charged you with. I have here on the tablet in all 3 of those cases documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Wilkerson?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Okay, pause right here because the hearing is about to shift from formal sentencing to something much more personal. The judge is no longer just reading legal procedure. She's about to deliver a direct warning that sounds almost like a final reality check before prison. And based on the tension in this courtroom, you can already tell she's completely fed up.
State tenors number 1 in each case.
No objection, Your Honor.
It's admitted in each case. Is there any evidence that Mr. Jones is not competent?
No, Your Honor.
All right, sir. In each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of those pleas. In cause number 25, DCCR 0523, find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 35 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 24, DCCR 2431, find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Sentence you to a term of 2 years in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
That line hit hard. The judge is basically telling him nothing escapes the court's attention. And when a judge starts referencing behavior inside the jail, asking about a bailiff's gun, causing problems with staff that can absolutely impact future parole decisions and how correctional officials classify an inmate. She's painting a picture here of someone she believes is escalating, not learning.
And then in cause number 25, DCCR 1352, I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated robbery. Sentence you in accordance with your agreement to a term of 35 years in the Institutional Division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I am making an affirmative finding of a deadly weapon in that case. These 3 cases will run concurrently, which means together at the same time. I'm going to hand you in all 3 of your cases the trial court certifications that shows that these were agreements that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a...
And there it is. A brutal ending to an already intense sentencing hearing. The judge openly says she expects him to spend the full 35 years because she doesn't believe he'll change. That's not just frustration. That's a complete loss of confidence in the defendant's future. The real question is, was this tough honesty necessary, or did the judge cross the line into being overly personal?